Your Honor, good morning, Happy New Year, and may it please the court. I represent an honest practitioner who recognizes his shortcomings, humbly admits that he could have done better, and is heartbroken at the prospects of sanctions in this case. Charles Fineblum knows that he has one coming, but after 50 years of exemplary service and no history of prior discipline, I don't believe that he deserves the punishment that petitioner proposes in this case. Just last year, this court in Milton described the sanction of an indefinite suspension as extreme, one of the strongest we may order against an attorney. And for a 75-year-old attorney, it would be tantamount to disbarment. I will argue three key points. First, that such a sanction would exceed the gravity and intent of his infractions. Second, that this record does not show the type of flagrant violations that would warrant this type of sanction. And finally, that mitigating factors warrant a more modest remedy. Contrary to what Bar Counsel has argued in his papers, this is not the Barton case. This is not a case of dishonesty, malpractice, malfeasance, or greed, and we shouldn't punish him as if it were. Barton involved a bevy of violations that brought 3 petitions for discipline. Ms. Barton delegated her trust accounts to a thief, failed to review bank statements. Even after catching her assistant stealing from clients, she refused to return unearned fees, lied to the court about it, and provided incompetent representation, bad advice, failing to appear for hearings, failing to file important papers. This court found that Ms. Barton embodied a dishonest and selfish motive. She refused to admit that she was wrong, ignored restitution orders, and harmed close to a dozen clients. The evidence in this case is very, very different. Unlike the 12 clients in Barton, no one testified against Charles Fineblum. The record here is devoid of those types of flagrant violations. There's no evidence of a dishonest or selfish motive, no intent to deceive anyone. Mr. Fineblum never delegated his finances to anyone. In fact, he monitored his account very, very closely. Regrettably, he did not keep the records that are required under the Maryland rules, and that is certainly a violation that we have acknowledged in this case. But there wasn't any incompetent representation. Not one client testified against him. And of more than 17,000 pages of records, not one page showed otherwise, that there was any type of incompetent representation. And in fact, Judge Nagel didn't find any incompetent representation. And that's a finding that has not been challenged by Bar Counsel in this case. It is absolutely true that Charles should have supervised his paralegal team more closely in a few instances, particularly in those cases. And we don't know how many there are, by the way, because Bar Counsel never really asked about how widespread it was. But Mr. Fineblum acknowledged that there were a few instances in which cases would be settled without him really knowing about it. Now, it is true that he met with each and every client personally to finalize those settlements. And so nothing was ever finalized without him knowing about it, meeting with the client and discussing it with the client, making sure that it was indeed acceptable. But I have taken some limited exceptions. On the whole, it's hard to quarrel with what Judge Nagel found in the main. I have taken a few exceptions, though, one of which is the violation as to communication under Rule 1.4b. Judge Fineblum concluded that clients lack awareness of the paralegal involvement. But in this case, Mr. Morris himself, in his own complaint, acknowledged that he knew who RT and Associates was, and that they were serving as Charles Fineblum's paralegal, and that Charles Fineblum was the attorney. The conclusion that many other clients with similar tort claims were unaware of this involvement, which is found at page 12 of the lower court's opinion, doesn't seem to hold water to me. Not a single client testified as to any awareness of anything. In fact, no one testified against Mr. Fineblum at all. Not one witness was called. And in fact, what we have here is therefore, without any communications in evidence, it'd be very difficult to find that there would be a communication problem. The stipulation among the parties was that paralegals are allowed to explain the terms of representation, to handle intake, to assist in signing up clients and the like. And that's exactly what happened in this case. I don't believe that in the main, this is a case where Mr. Fineblum knowingly aided and abetted the unauthorized practice of law under Rule 5.5.
I have a question for you on what you were just talking about. It looks like the hearing judge's finding was not that the clients did not know that the paralegal firm was involved. It was that they didn't know that the paralegal firm was effectively in charge of the representation for most of the representation.
Well, I don't see, Your Honor, where the facts are that would support any finding of that kind, because petitioner, with the burden of producing clear and convincing evidence on the point, didn't call any witnesses. Not a single client testified, not even the complainant showed up to testify against Mr. Fineblum. And he also could have called someone on the staff of RT and Associates to say, here's the nature of the explanations that we provided. He didn't do that. And that's the burden of proof and the record that this court would need to conclude that there would be a communications violation in this instance.
We haven't seen the testimony, obviously, but your client testified, is that correct?
That is correct.
And this was a 10-year relationship with this paralegal firm.
Just about.
And if I understood the hearing judge's opinion correctly, the bills that your client sent to that firm did not involve an hourly rate or anything keyed to the actual specific work that they did. Is that right?
That is correct. It's very unclear exactly how the compensation was arrived at. It is true that at one point, and Mr. Fineblum wrote to Bar Counsel and admitted that the value of the case did play some role in the arriving of compensation, but it's evident that there wasn't any type of set formula or percentage used. At least to my math, there's absolutely no rhyme or reason in some instances. So it was done apparently on an ad hoc basis.
And it was done that way for the full 10 years of that relationship?
I don't know that. In fact, that's not a question that Bar Counsel pursued, and Bar Counsel didn't produce any evidence on the point. It's really unclear, and that makes it very difficult to find by clear and convincing evidence that there was a splitting of fees here. The rule itself in 5.4 does allow profitability to be taken into account when compensating employees or other individuals. The problem here is, there was a finding of fee splitting, but in reality, Mr. Fineblum did report all of the fees on his taxes. He paid, and I don't like the optics of it, but this isn't the case of optical illusions. It's got to be based on clear and convincing evidence. He did pay RT and Associates for quite some time until I corrected the situation out of trust fees, out of his earned fees in trust. Now, that's not a prohibited trust transaction. He's allowed to do that. It's not great for optics or the audit trail, if you will, but there's nothing prohibiting that. It seems that the gravamen of what Bar Counsel complains here, Your Honor, is that the payroll far exceeded his profits. And frankly, I don't know anyone employing a team of 6 paralegals whose payroll would not exceed their profits. In the aggregate, that's almost always the case. And if I could find someone to show me otherwise, you could make a fortune. Obviously, Charles Fineblum didn't make a fortune, and his business practices or his acumen as a businessman left quite a bit to be desired. But to conclude that there were fees that were split, to me, on this record, it's highly unclear and not sufficient to say that he was taking fees. Now, again, this is the optics that petitioner is going for here. It just
I understand, Mr. Kramer. I understand that there's evidence in the record about what the profits or losses were of Mr. Fineblum's firm. Is there any evidence in the record of what his revenues were each year? What I'm getting at, what I'd like to know if it's in the record is, has anyone done a calculation of what percentage of the overall revenues went to the paralegal firm?
No one has done a calculation to my knowledge, but it is in the record because my client's tax returns are in the record, and his Schedule Cs for his business would reflect that he grossed hundreds of thousands in fees. Unfortunately, it will also reflect that he didn't profit very much, and there were even a couple of years where he had losses. Part of that is because of the team of paralegals he was paying, and even though he did save on some payroll taxes and burdens, you pay a premium for that when you outsource, and certainly he did. The other factor here is that he was only charging 25% contingency fees. So the double whammy of that didn't amount to a very profitable business, quite frankly. And in reality, once he jettisoned the entire relationship that we're talking about today, I believe his revenues probably improved because he was really operating in many ways at a loss. But whether he's profitable, whether he's operating at a loss, that does not bear on Rule 5.4. Rule 5.4 doesn't say you may only compensate your support staff to X percentage. When it does, we will know for sure that there is a limit on what you can pay an entire staff. But until that happens, and until that's written in, one can't simply compare his net profit with gross revenue and say, fees are being split here. That's part of the problem, I think, with the record that this court has today. As far as unauthorized practice is concerned, this was a high volume PI practice. And oftentimes lawyers will call this a paralegal practice. Why? Because it's very paralegal dependent. Paralegals handle the incoming calls, the intake, the retention. They help with negotiations and settlement. Even though Mr. Fineblum finalized the settlements himself and litigated all of the cases himself, there was never, contrary to what petitioner is arguing, a delegation of strategy. These were not cases involving high strategy. These were mass PI cases, soft tissue in most instances. And the strategy is very rote. You essentially establish at the outset, here's what you do to process a case, and you do it. It's often the rote compilation of medical records, compiling the itemizations, taking care of rental cars, things of this kind. And a large percentage of the work is always done by paralegals. It would seem that below, at least, Bar Counsel was arguing that, well, these aren't in-house staff. This is outsourced. These are off-site independent contractors. But there's absolutely no rule against the use of off-site independent contractors. And candidly, if there were, there would be an enormous industry in our legal community that would be shut down instantly. The fact is that they are used, and they're used to great effect, particularly by smaller firms who then get the resources that a larger firm would otherwise have. If you don't prosecute a large law firm for using paralegals in this way, it seems unfair to punish Charles Fineblum.
I understand that Mr. Fineblum, you've said a couple times he finalized the settlements, but in the course of before the clients agreed to settle, what lawyer was providing advice to these clients about whether the settlement amount was in their best interest? What lawyer was doing that piece of it?
The lawyer would be Charles Fineblum. What we do know from Charles Fineblum is that there were some instances where that did not happen, and that's a violation. There's no challenging that. But to say that that was widespread, to say that that was routine, to say that that went on for 10 years, you need evidence. And there isn't any evidence, because when Mr. Fineblum was questioned about it, both at the statement under oath and at trial, he would admit that there were times when that did happen. If you have a burden of proving something by clear and convincing evidence, you have a burden of asking more questions after that. But that's not what happened here. The same was true, for example, in the commingling. That's a perfect example. There's a finding a conclusion that Mr. Fineblum impermissibly commingled. Why? Because in deposition, he admitted that there were times when he left some earned fees in longer than he should have, maybe for days or weeks. The problem here is this. There isn't any evidence as to how many transactions we're talking about, the amount of those funds, the duration that they were left in trust. And if somebody from this court is going to be assigned an opinion to write about something like commingling, for example, you need a record of facts. And what happened is, after he admitted that, our counsel pretty quickly ended the statement under oath and never asked another question about it. Now, it's, do we want to penalize a respondent's candor in admitting that, well, at some point, at some time earlier, I may have violated a rule? You need more than that in order to assess not just whether an infraction occurred, but what was the severity. This court needs to weigh that severity to determine what type of sanction is appropriate. And particularly when the sanction proposed is an indefinite suspension, there needs to be much more clear and much more convincing evidence of the frequency and severity of the infraction. That we do not have in this particular case. What we do have, however, are loads of mitigating factors that were not at all in play in the Barton case on which Bar Counsel relies. And that seriously distinguishes this case from cases imposing far more serious suspensions. We have 50 years of practice without prior discipline, no evidence of a dishonest or selfish motive. In fact, Bar Counsel himself remarked about how honest and open Mr. Fineblum has been throughout these proceedings and investigation. There were good faith efforts to rectify in a prompt manner. He was fully cooperative throughout the proceedings, and his character has been above reproach. Members of the bench and bar testified that this is an honest man. This is not a person who's going to pull the wool over your eyes. And in fact, Judge Chester said something that I think is particularly important here, and that is, he's the kind of guy who would vomit guilt in a deposition. And I will admit to all of you, I couldn't kick him under the table hard enough to stop that. I mean, the bottom line is, this is an individual who, when it hurts him, he's going to talk about it anyway. I mean, the most significant witness against Charles Fineblum in this case was Charles Fineblum. And Bar Counsel thought that it didn't need any other witnesses and didn't call any other witnesses, but I think it did. The bottom line is that he is heartbroken. He recognizes the shortcomings, and he has taken action to correct them, which is why the key factor in this case is that this is conduct that is unlikely to recur. If the purpose here is to protect the public, then we need a sanction that fits, particularly in a scenario where this is not an individual likely to be back before you. And I think that the cases involving similar infractions have imposed reprimands to short suspensions. And in that respect, I would argue that Sapero from 07, McDowell, Harris-Smith, Goldberg case, all of which have been cited, those are cases which recognized that where you don't have a dishonest and selfish motive, greed, dishonesty, things of that kind. And frankly, in some instances, even where there was some dishonesty, that an indefinite suspension is simply not appropriate in many of those cases. I'll take Sapero as one example. Here you have trust account record keeping, as we have here. You had a finding of commingling. Of course, on that record, they actually had transactions that they were looking at, rather than a more blanket, amorphous admission that at some time in the past this occurred. Client communication problems, but there was no harm to any client, no fraud. The remorse and remedial measures were there, and the likelihood of recurrence was virtually nil. In those cases involving similar circumstances, this court found that a reprimand was indeed appropriate to send the message and make the point and protect the public. The same was true in the McDowell case. An associate had falsified documents, robo-signed many deeds and affidavits in 900 cases. The managing partner failed to supervise under Rule 5.1 and 5.3, and a reprimand there also was appropriate. Harris Smith is another case that involved a 30-day suspension in which a non-licensed attorney engaged in what this court concluded to be the unauthorized practice of law, and also failed to supervise non-lawyer assistants. A lot of those very same infractions were charged in this case, and a 30-day suspension was imposed. I don't believe that this is a situation which merits a stronger sanction. Thank you.
All right. Thank you, Mr. Kramer. We will now hear from Mr. Hine.
Good morning. May it please the court, Raymond Hine on behalf of the petitioner. The respondent in this matter engaged in a decade-long working relationship with an individual named William Ronald Tillman and his company, RT and Associates, by which the respondent allowed Mr. Tillman, an independent paralegal, to provide legal services to personal injury clients without supervision by a licensed attorney. Through that arrangement, the respondent facilitated Mr. Tillman's unauthorized practice of law. He also impermissibly shared legal fees generated from the personal injury cases with RT and Associates. Contrary to the manner in which the respondent portrays the conduct, it cannot be deemed inconsequential to clients who believe they had retained the respondent's services. This court has established a rigorous process for admitting attorneys to practice law in this state. That admission process allows attorneys to exercise the privilege of representing clients and to exercise professional judgment in advising clients. Neither Mr. Tillman nor anyone working for him had earned that privilege, and the respondent knew that. Nevertheless, the respondent abdicated the day-to-day oversight of his personal injury practice to the paralegal service operating from Mr. Tillman's residence. The unsupervised activities of RT and Associates included conducting client intake meetings, signing up clients to representation agreements with the respondent, identified as the attorney, maintaining client files at the office of RT and Associates, coordinating clients' medical treatment and insurance claims, using the respondent's letterhead to send correspondence, including demand letters to insurance carriers, signing the respondent's name to letters he had not reviewed, negotiating with insurance carriers, and settling client claims in certain instances without the respondent's input.
Mr. Hine, are you suggesting that conducting client intake meetings should always be undertaken by a lawyer as opposed to a paralegal?
No, Your Honor. A key, as the court has discussed in many cases, including going back to Attorney Grievance Commission v. Hallman, which is cited in our recommendation, the key is supervision. In the Hallman case, the court addressed certain activities that paralegals may perform, and client intake meetings may be part of that equation as long as the paralegal or non-attorney staff is supervised by the attorney in that activity. But what the court said in Hallman is that non-attorney staff may not give legal advice, accept cases, set fees, appear in court plan strategy, make legal decisions, or chart the direction of a case. Except for appearing in court, it's our contention that the respondent permitted Mr. Tillman to engage in each of those activities, and he failed to supervise Mr. Tillman and the staff at RT and Associates in the performance of certain activities that may otherwise have been permissible.
So, and I think others have expressed this, we obviously haven't seen the record in this case, but what evidence is there in the record, if you will, as far as the supervision or lack thereof that Mr. Fineblum provided?
So the evidence, Your Honor, is Mr. Fineblum's own testimony during his statement under oath. And there are several examples of that the hearing judge referred to in his findings of fact. These include the respondent testifying that he was getting maybe 75 to 80% of his personal injury clientele referred to him from RT and Associates after the clients, excuse me, after the clients initially met with someone at RT. And that reference is in the record. Petitioner's Exhibit 15A is the statement under oath transcript. That testimony is at pages 79 and 80. Mr. Fineblum further acknowledged that Tillman's people were communicating mostly with the clients at page 26 of that transcript. He testified that there were cases that Tillman's people at RT settled, and there were cases that I settled, indicating that there were two different categories of cases, and that's also at page 26. And finally, Mr. Fineblum testified that he was not aware of some of the cases whose clients were settled by Tillman or staff at RT and Associates. That's at pages 27 and 28 of.
So is there, I guess, just to understand the testimony, is the testimony that these cases were settled without any involvement by Mr. Fineblum at all?
That's correct, Your Honor. Mr. Fineblum acknowledged that in his testimony. And again, it's not as to every case, but he acknowledged that there were some clients he was not even aware of, had never spoken to, and whose cases were settled by Mr. Tillman. In addition
is there any evidence in the record as far as how many instances this would have occurred?
There is no precisely defined number of cases. The only testimony or evidence was that the respondent acknowledged that some of the cases were settled by Tillman without his knowledge or participation, but there was no quantification of that in terms of a precise number. But what we do know is that from his own testimony, there was this longstanding systematic relationship that went back a decade, and that by which he enabled the staff at RT and Associates to run a personal injury law practice from a different location than the respondent's own law office. And also in response to your question, Judge Booth, there was additional testimony from one of the respondent's own character witnesses, Judge Chester, who was asked on cross-examination whether Mr. Fineblum had described to her what he thought he had done wrong. And her response at page 54 of the hearing transcript addresses this. Judge Chester testified. He said that he basically had said that he wasn't supervising appropriately. He basically allowed someone to take over most of the management of his cases, and he should not have done that. And while they were under his name and so forth, but he wasn't giving them the personal attention he should have. She goes on to testify that it gave the appearance that they were practicing law when they were not. This is Mr. Fineblum's characterization. But he acknowledged that he should not have participated in that. He should have had much more hands-on in this and looked at it differently than he did. So even one of the respondent's character witnesses described the respondent's lack of supervision over the activities.
So just to back up, because you mentioned that the paralegal firm was running a separate law practice. There's nothing in the record that they maintained a separate trust account, is there?
No, Your Honor.
All all of the funds ran through Mr. Fineblum's trust account.
Yes, Your Honor, that's correct.
And I think I read in the record somewhere that while they maintained a file, Mr. Fineblum's firm also maintained a duplicate file.
There was testimony from Mr. Fineblum that the original files would be created at RT and Associates, and they would send him over copies of materials from that file. I believe it was on an as needed basis, but I'm not entirely certain that there was clarity to the respondent's testimony as to whether he received a duplicate file in every instance.
And I guess one other question, is it the case that all of the files were actually, the fees were all a 25% contingency fee?
Yes, that's correct.
Okay, so there was no differentiation as far as negotiating with clients as far as what the set fee would be for the representation. It was in all cases 25%.
Yes, Your Honor. That seems to have been the business model adopted by Mr. Fineblum in conjunction with Mr. Tillman. And so the 25% contingent fee seemed to be pretty standard across the board. And I'll move from that into the discussion of the attorney's fees, the sharing of the attorney's fees. Contrary to the way Respondents' Counsel seems to portray it, it's very clear from the testimony that Mr. Fineblum himself provided what the circumstances were that from the contingent fee generated in individual cases, he testified that from those individual cases, he would perform what he described at page 62 of the statement under oath transcript as, quote, kind of a general calculation where part of the value of the services was a percentage. And so, as indicated, there were no invoices or billing statements generated by RT and Associates for services in any individual cases. Instead, Mr. Fineblum paid RT and Associates a portion of the contingent fee generated in each case. That is precisely the type of fee sharing arrangement that Rule 5.4a prohibits. And the RT and Associates and Mr. Tillman and the staff at RT and Associates were not the respondent's employees. So the exception that that Respondents' Counsel refers to in Rule 5.4a4 is not applicable on that basis alone, because that exception refers to an employee compensation plan. RT and Associates was an independent contractor service, and a percentage of contingent legal fees generated in individual cases was being forwarded to RT and Associates.
Mr. On that point, is it your position that had these been employees, the compensation would have been acceptable under the rule, but because they're a independent contractor, it's not? Is that the distinction?
No, Your Honor. I think the argument that Respondents' Counsel was trying to put forth was that this was equivalent to a payroll situation, but it really was not. And that's the distinction I'm trying to make. Obviously, attorneys can pay employees who are on their payroll a salary or whatever other terms of compensation are arranged based on the level of services provided. In this instance, these were not employees who were on the respondent's payroll, and therefore the sharing of a portion of the legal fee from individual cases violated Rule 5.4a.
Mr. Hine, is it your position that attorneys can never contract with independent contractors for paralegal services without running afoul of the rule?
No, Your Honor, that's not our position at all. And by the rule, are you referring specifically to Rule 5.4a, Your Honor?
Yes.
Yes. So if an independent contractor provides services on a contractual basis where the terms of the compensation are set forth, for example, independent contractor is to be paid X amount of dollars per hour of service, that would be an acceptable arrangement for the respondent to compensate the independent contractor, non-attorney, based upon that arrangement. That is not what was occurring in this case. RT and Associates, again, did not submit any type of invoices or billing statements for the services that it rendered. And instead, as mentioned, there was this percentage-based calculation where the respondent was paying them a portion of his contingent legal fee out of individual cases.
Do you have any case law that you rely on for the distinction between an independent contractor billing with invoices versus a percentage being determined as being acceptable under the rule or not?
I don't believe I have any. I don't have any case law that specifically addresses that point, Your Honor. But I was going to bring up another case, Attorney Grievance Commission v. Chapman, which is 430 Maryland 238, 2013 decision. That case involved a set of circumstances where an attorney entered into a consulting agreement with a non-attorney's firm to provide loan modification services. And in that case, there was a determination that Rule 5.4 was violated because a portion of the fees generated from these loan modification representations, in fact, a substantial portion of those fees was paid to the consulting firm, the non-attorney consulting firm.
Is there any evidence in the record, one way or the other, as to whether the RT firm, in any cases where there was no recovery at all for the client, was there evidence whether RT got paid anything for their effort on those cases?
No, Your Honor. There's no evidence that addressed any cases that did not generate a recovery. So I'm unable to say, and the evidence is, the record is devoid of evidence as to what happened in those instances.
I have a question, Mr. Hine, about the 1.4 communication violation. The hearing judge found, as Judge McDonald pointed out, that there was a failure to communicate that R&T was in charge of the cases. The representation of Mr. Morris appears to have been very short, just 1 month approximately. What were the actions or the things that R&T was in charge of that were not communicated to Mr. Morris?
Well, specifically in the Morris case, the evidence that was introduced largely arose from stipulated facts that Mr. Morris was aware that Mr. Fineblum was an attorney and contacted Mr. Fineblum's office, but was connected to Mr. Tillman at RT and Associates, that he only had communication with Mr. Tillman and never, in fact, spoke to Mr. Fineblum. So in terms of the communication, there actually was no communication between Mr. Fineblum and Mr. Morris. The court's finding with regard
Mr.
to
Hine.
Yes, Your Honor.
Mr. Hine, excuse me, I'm curious, and I follow up on Judge Watts's question to you. When you say Mr. Morris contacted the office of Mr. Fineblum, but was connected with RT, was there an automatic forwarding of the call, or what? This is more curiosity than anything else. I don't know if there was a person who answered and said, well, let me transfer you to so-and-so at R&T.
Right, Your Honor. That's not entirely clear from the record. My understanding was that Mr. Morris had a phone number that was associated with Mr. Fineblum's law practice that he contacted, and however it occurred, and I'm not entirely sure how that happened, he was put in touch or connected to Mr. Tillman. I don't know that there was any type of forwarding of the phone call, or if the phone number actually was for Mr. Tillman's office at RT and Associates.
Okay, another question, more out of just trying to get a very general view of the relationship, as well as the nature of Mr. Fineblum's practice day to day. Did he carry, independent of all of what was going on through R&T, was he carrying, did he have clients? Was he doing other work? Was he essentially doing little to nothing, and R&T or RT was essentially processing much of the work within the practice?
I believe, Your Honor, that the most substantial portion of Mr. Fineblum's law practice did involve these personal injury cases. He did testify to doing some other work, if I recall, that may have involved minor district court criminal or traffic type violations. But that part of his practice was kept separate from the personal injury practice through which he was operating with RT and Associates.
Thank you.
And I did want to return to Judge Watts's question about the Rule 1.4b violation. The hearing judge made the determination that Rule 1.4b was violated, not simply on the Morris case, but on the general basis that the respondent, excuse me, admittedly had little to no communication with clients whose cases were being exclusively or substantially managed by RT and Associates. And that the evidence in support of that was the respondent's own testimony. So I think it was fair and reasonable for the hearing judge to draw the inference and rely on circumstantial evidence that in support of the conclusion that the respondent failed to explain to such clients that non-attorneys were effectively in charge of their cases, and that he did not disclose sufficient information as to the role, participation, and agency of RT and Associates. That was the basis for the Rule 1.4b violation, which again was not limited simply to the facts of the Morris case.
It would just appear, as to the Morris case, that Mr. Morris was very much aware that he was dealing with R&T, and that possibly gave rise to the complaint. And I was wondering what in that case Mr. Fineblum was in charge of that Mr. Morris didn't know about or wasn't communicated to him.
So I think what was not communicated to Mr. Morris or to many, if not all of the clients, was that this finding that the hearing judge made, that a group of non-attorneys or a single non-attorney at RT and Associates would be in charge of oversight and management of their personal injury case without Mr. Fineblum's involvement. And in fact, again, Mr. Fineblum testified that he had little to no communication with many of the clients over a period of time. And it was normally when the cases were approaching a point where it appeared that perhaps litigation might be necessary that Mr. Fineblum became involved. And this is part of the overall picture that the respondent himself gives in his testimony, that he knew that RT and Associates was managing these cases, and he was lending his attorney's license to RT and Associates to process these personal injury cases, and only would become involved as the cases approach the point where there might be a necessity for litigation going forward. So that's part of the
At that point, the clients would become aware of Mr. Fineblum's involvement. Is that right?
Yes, out of necessity. Mr. Fineblum was the one who would file suit and handle the cases that went to court. And to be fair, I mean, there were some instances, according to Mr. Fineblum's testimony, that he did become involved in settlement negotiations that did not end up going to court. But for the most part, the cases were processed from intake through settlement by RT and Associates. And then again, going back to Judge Booth's question, I believe the settlement funds were processed through Mr. Fineblum's attorney trust account. So he did become aware of the settlements in order to handle the funds that came into the attorney trust account.
And Mr. Hine, do you agree that none of the clients were harmed or injured by Mr. Fineblum's conduct?
No, Your Honor, we do not agree with that because, again, while there may not have been specific harm that we can point to in an individual case, the harm that arose is that the clients believed that they were retaining Mr. Fineblum as an attorney and were never told that non-attorneys would be handling their cases from intake through settlement without Mr. Fineblum playing any role. And to address one of respondents' arguments, these cases, while there may be some similarity or some usual practices that are followed in personal injury representation, if the court were to accept the respondent's argument, it would be equivalent to allowing personal injury cases to be managed by or to be handled by non-attorneys. That is not what the personal injury field requires. But clients are required to be represented by attorneys, not by non-attorneys, in negotiating with insurance carriers and in reaching settlements of their cases, and to rely on receiving the professional judgment of attorneys in those cases. So in addition to the issues relating to the lack of supervision and the unauthorized practice of law, there is the misconduct involving Mr. Fineblum's failure to keep required trust account records and to perform monthly reconciliations. Mr. Fineblum admitted to this during his statement under oath, and he also acknowledged that there was commingling of funds in his trust account by virtue of the fact that he allowed earned attorney's fees to remain in the account sometimes for days, weeks, or months, according to his testimony. And the hearing judge relied on that testimony in finding that he did commingle funds and that he otherwise failed to manage his trust account in accordance with the rules adopted by this court. In Attorney Grievance Commission versus Bell at 432 Maryland 542, which is one of the cases cited in our recommendation for sanction, Judge Green, writing for the court, wrote, the common thread running through the cases mentioned is that an attorney's careless or uninformed mishandling or commingling of client trust funds in violation of the safekeeping requirements of Rule 1.15, absent any intent to defraud the client or financial loss to the client, will ordinarily result in a sanction of indefinite suspension. The weighing of aggravating versus mitigating factors ordinarily will bear on whether and how long a minimum sit-out period may be imposed.
Did that case involve commingling in the sense of this case where the attorney was simply not moving earned fees from the trust account into another account?
I don't believe the Bell case did, but the Barton case that we cited more so for the lack of supervision issue and the unauthorized practice issues does involve an issue of commingling in violation of 1.15b and previous Rule 16-607. That is similar to that issue where unearned fees were not being removed promptly from the trust account. So that was an element in the Barton case.
My recollection, though, in Barton was that the attorney failed to take responsibility and there were significantly less mitigating factors in that case.
Yes, Your Honor, I would agree with that. That in general, there were more aggravating factors and certainly fewer mitigating factors in the Barton case than we have in the current case involving Mr. Fineblum.
Mr. Hine, to the point of which I think you might shortly be getting to, but I'm rushing you to it. Speak a little bit more, if you would, about the sanction that you're recommending, given, you know, a sort of a holistic approach to the, Mr. Fineblum's practice, the length of time that he's been working with RT, maybe even his age, I don't know, his remorse, et cetera. Why indefinite suspension? Or why not something shorter?
Yes, Your Honor. So there are two branches of misconduct in this case, one being the systematic failure to supervise, which enabled the unauthorized practice of law by RT and associates. And then the second branch involves the failure to comply with trust account management requirements and some element of commingling. As mentioned in the Bell case, indefinite suspension has been deemed the appropriate sanction for the trust account issues. And with regard to the other misconduct in both the Barton case, and I'll also re-mention the Chapman case, there were violations of Rule 5.3 and Rule 5.4 in the Chapman case, which resulted in an indefinite suspension with a right to reapply after 90 days. The consistent position that the court seems to have taken, however, is that for both of these branches of misconduct, indefinite suspension is deemed an appropriate sanction. And the court's disciplinary jurisprudence serves not only as precedent for what sanctions should be imposed, excuse me, but also guidance to attorneys for what misconduct they should seek to avoid. Having had the benefit of these cases decided by the court previously, it's our position that an indefinite suspension is appropriate for both branches of misconduct. And that, again, while the Chapman case had a minimum period, we would defer to the court to determine if there should be some minimum period applied before reinstatement can be deemed appropriate. Thank you.
All right, thank you. That was helpful. And it looks like we have 10 minutes remaining, Mr. Kramer, so back to you.
Thank you, Your Honor. I'll tell you, I'm a bit of a baseball fan, and I'm kind of a baseball nerd. I've read the Major League Baseball rules, and I'm not ashamed, or maybe I should be ashamed to say that. I could probably quote them better than I can sometimes the rules of professional conduct. But in baseball, there's this controversy that you may have read about if you look at all the sports pages. And it's that there are unwritten baseball rules that aren't written down. Players get into fights about them. Oh, you shouldn't flip your bat. You're not allowed to, score. You're in the bottom of the ninth and ahead 10 runs, things of this kind. And I've learned now that there are unwritten rules that Bar Council maintains. One is that although you can compensate people on the basis of profitability, you can't if they're independent contractors. That you must communicate with all clients within the first 30 days of representation. I didn't know about that. I know there's a rule about communication. And I also know that we stipulated in stipulation 6 of the record that paralegals are allowed to act as liaisons for attorneys in facilitating attorney-client communication. And frankly, if you're at Science and Kirk or any of the big shops, that's exactly who you're going to be talking to if you're one of their clients. We shouldn't treat a sole practitioner who outsources that any differently, at least not if there's no written rule that prohibits it. And there isn't in this case. But we also have in this case unrecorded evidence, an unclear record. The communication is a good example of that. We don't have any communications in the record. If I have the burden of proving by clear and convincing evidence, which I don't, but Bar Council does, I know how to prove what was told to clients. I'd call some clients. I'd at least call one who says, I was completely unaware of this. Maybe that's why they didn't call Jerron Morris, because Jerron Morris was aware of the relationship between Charles Fineblum and RT and Associates and its principal, Mr. Tillman. He was, and we know that not only from our stipulations, but from the complaint itself where he describes that relationship. He did not act under some confusion in any event, but if we're going to prove client confusion and a lack of client communication, you call the clients, or you call somebody at RT and Associates to say, here's what we told them. No, we failed to tell them this. That's how you prove, by clear and convincing evidence, a communication problem. But that's not what was done here. As far as the division of labor, Judge Watts asked some questions about this. In most of these high volume personal injury practices, paralegals do process the cases. Lawyers try them. That's the way the business model works. You couldn't handle a large volume of personal injury cases if you had to work yourself at all of the client communication, at compiling all of the evidence, at itemizing and sending those bills and letters of representation over to the insurance companies. And a lot of these letters, routine correspondence as they are signed in the name of the attorney with the attorney's approval. What the
Mr.
attorney—
Kramer, I think sorry to interrupt you, but I think you said at some point in your prior argument that you had put a stop to this relationship in some fashion. Does the record show what Mr. Fineblum has done since that changed in terms of paralegal support, whether he has in-house paralegals now or has moved on in some other way to outsource? Did that come up in the hearing?
Well, no, but what I put a stop to, as I indicated earlier, was the notion of paying from earned fees that were held in trust. I just didn't like the audit trail. I didn't like the optics of it, quite frankly. But yes, we certainly, when these things came up, we put a stop instantly to the relationship with RT and Associates. When you're under this microscope, even if you have defenses, you just want to stay as far from the edge as you can. And that certainly would be the advice that I provided. What he did say is that his practice today is very different. He focuses on those cases he personally can handle without the need for paralegal support. So he truly is now a one-man shop, if you will. And frankly, probably his revenue picture looks even a bit better than it does in the record here, because he doesn't have that mammoth expense of funding the staff. This case did not involve the delegation of trust funds. It did not involve an attorney who, as in Barton and many of the other instances, failed to manage his trust account. He managed this very directly himself. The infraction in this case is that he didn't keep the reconciliation reports on a monthly basis the way he should have. That probably puts him in the company of 90% of lawyers out there, but it doesn't make it right, and it is an infraction. But what we don't have here is the kind of infraction, flagrant infraction, that would justify an indefinite suspension, as in the Barton case. Bar counsel relies on the Hallman case. Well, Hallman involved a failure to maintain the trust account, failing to respond to bar counsel, quite unlike Mr. Fineblum, and assisting a layperson in the unauthorized practice of law. That amounted to a 90-day suspension. That was not an indefinite suspension case. And Hallman is what Mr. Hine has relied upon here. This is not like the case of Jimmy Bell. Mr. Bell had 45 cash disbursements from his trust account. He also had a prior reprimand and far fewer mitigating factors than the court found in this case involving Mr. Fineblum. I know he also cited the Mahone case. I argued the Mahone case before this court back in 2016. Mr. Mahone had 3 prior sanctions, 2 reprimands and an indefinite suspension. And this court imposed an indefinite suspension upon him once again for infractions that were quite similar to what it had punished previously. We have a man here who in 50 years almost of practice has an unblemished record. It isn't to say that we excuse any of the infractions here, but it is to say that a punishment akin to those who have had a long record of disciplinary problems and prior sanctions, that kind of a sanction is not warranted in this case. He's 75 years old. If he gets indefinitely suspended by this court, he's not coming back. And frankly, I don't think that would be appropriate here, particularly on a record that is so undeveloped. It's kind of a shame that this court doesn't have the record. I don't know what happened there, but what I can say is when you get it, and whoever's assigned this opinion is going to have to come up with facts, not with hyperbole, not with blanket statements that he abdicated his practice because so much was done by paralegals, which would be true in virtually every high volume personal injury practice known to man. All right. To say he abdicated isn't a replacement for evidence, particularly when one has to come up with clear and convincing evidence. When it came to fees, for example, yes, my client did say that sometimes he used a percentage, but the math doesn't compute. All right. He, once again, as Judge Chester said, vomited guilt to make himself look worse than he really was. But if you look at the actual facts, you don't see that. In fact, in some instances, what he had taken out for case A may have compensated for a few other cases. And you'll see this because we provided schedules of all of the fees and all of the support expenses recorded in all of the cases, hundreds of them for hundreds of clients, but not one was called by bar counsel in this case. As far as my client's files, we produced close to 18,000 documents. And in the room behind me, you would see nothing but banker's boxes behind me at the time we produced what my client held on hand to bar counsel. He did maintain significant files, and he did testify at the hearing, certainly, that this notion that he completely abdicated, this notion that he had absolutely no hands-on whatsoever is simply unfair, that he could have done better. But this idea that he completely ignored and abandoned ship to some unlicensed outfit is simply unfair, just as unfair as an indefinite suspension would be in this case.